Number 16, matter of Larchmont Pancake House versus the Board of Assessors.
Oh, sorry.
Thank you. Okay, good afternoon, Council.
Good afternoon, Your Honor. Madam Chief Justice and Associate Justices, may it please the Court, Kevin M. Klein for the appellant, Larchmont Pancake House. Your Honors, may I reserve 2 minutes for rebuttal?
You may, sir.
Thank you. The real property tax law, as
Counsel, I'm sorry, I just need to clarify something. At the point of the death of the mother who creates the trust, once she has passed away,
yes.
what's the status under the trust of Ms. DeGast?
Ms. DeGast at that point is the devisee of the trust, and as the trust is effectuated and implemented, she eventually becomes, by terms of the trust, the property is devised to her in fee.
So
where
she has a
eventually
vested,
owns
she's
it.
got a vested interest.
She has an interest day one, Your
She
Honor.
had a reversionary, maybe future interest before this because it was revocable, but at this point it's vested.
She had an ownership interest at that time.
She's going to get this property, or her heirs, I assume.
Absolutely.
Okay.
But is
She had
there a
multiple
ti-
levels of interest.
Is there a time limit for that to happen? I'm not, I read it, and it seems like upon the death of the person who made out the will, that this is going over to the named beneficiaries, but it seems to take 4 years.
Well, Your Honor, I guess we cannot hold, especially in a remedial statute, Mr. Gass responsible for how long this trust took to be effectuated. It was also it was part of the property was in New Jersey, part was in New York. It was complicated. I don't
Under
really.
the terms of the trust, was there a time that had to happen?
I don't think that there is a time that it has to happen.
So
I think
up
the
until the
certainty that it
time-
would happen is the relevant
But
fact.
up until the time the trustees decide to do it, that property's in trust. It's held by the trust.
That's correct.
And I think it was, at least to me, somewhat confusing throughout all of the arguments in this case being made, where there seemed to be a conflation between the trust, the trustee, the trust beneficiaries, the business. And it seemed to me that Ms. DeGast was arguing that her authority to commence this proceeding was as the president of the business, not as the devisee of the trust.
Well, Your Honor, her interest and her authority there were several layers of that interest. She was the owner of the business that was operating out of the property. She was a devisee under the trust. She was under a Mack versus Ramapo type analysis. This was comparable to a contract vendee with the certainty that she would eventually become the owner of the property. But she had multiple levels of interest in this real estate, and the standard here is whether or not this assessment had direct adverse impact on her pecuniary interests. It did on several levels.
Can I ask, so the trust, the trustee, is responsible for the corpus. I would think they get the tax bills. Did they send it to her? I mean, how does she know what to pay? How does she know what the bill is? Give me a sense of the mechanics.
On top of her multiple other relationships, it's a familiar relationship.
Okay.
Your Honor, Larchmont Pancake House paid these taxes every year.
No, I understand that, yes.
What about the fact that she was under no obligation to do that? She voluntarily did that. Does that make a difference?
No, I don't think it does, Your Honor. I think the standard.
So if she said, I'm not going to pay this anymore, what would happen?
The property would have been lost. Her business would have been threatened. Her familial connections to the property.
Or maybe the trust, it would have been paid out of the trust.
Well, she also had an eventual ownership interest in the property, but her business was operating there, Your Honor. Again, did it have a direct adverse impact on her pecuniary interests?
Clearly isn't enough, right? Just the direct impact. is not enough. I mean, you could not pay the taxes. You could pay the taxes to the landlord. If the landlord doesn't pay, it's going to be a direct impact, and we've said that's not enough, right?
Right, well, yeah, in cases where it could be interpreted as remote or consequential, but that's not the case.
That's consequential. I pay my landlord the taxes, and if he doesn't, or she doesn't turn them over to the taxing authority, I lose my house. That's not that remote, right?
In this particular case, because of all the relations of Mr. Gass and Larchmont Pancake House, the petitioner here, to this property.
Does the taxing authority have to look at that? I mean, does it have to say, you know, okay, what are the terms of the trust? Could they sell the property during the 4 years they held it before they distributed it or not? Is it a revocable trust or not? Why isn't it a very simple rule that is, if you're paying the taxes directly and you have an obligation to pay, you have the right to bring this
Your Honor,
action?
the Board of Assessment Review, if there were questions, what the respondent is arguing here is that you have to be the owner, and only the owner. The Board of Assessment Review has the authority to bring in, take testimony, question this. That is part of their function.
The question, what?
To question who may or may not have an interest, whether or not there is documentation that they may need to.
And then hire a trust lawyer to look at the trust agreement? Because your argument seems to be centered a lot on the beneficiary of the trust now.
It's not just a trust document, Your Honor. It's, again, her business relationship to the property.
But isn't the point of their authority to determine who the owner is? I mean, that's something that you know, this is not a court. This is an administrative proceeding, and you know, maybe in this case it would be simple to figure out what the beneficial, you know, who was going to end up with this property and who was doing what and what the relationships were. Maybe it isn't so easy, but doesn't the Board of Assessment Review need a simple rule so that it can do its part and then it can get to the court and legal questions can be decided there?
If I understood your question correctly, you started saying, isn't it their job to determine who the owner is?
Who the owner is, right.
That's not, because that's not what 524.3 says.
Well, let's assume we think that's what it says. Wouldn't that serve the same purpose than all those powers that you're talking about to bring people in and take testimony or whatever it is? It's to determine who has the, let's put it this way, who has the authority, right? But if that is, if that means owner, then it's a relatively simple inquiry as opposed to what you're suggesting they're supposed to do.
Well, again, we're dealing with a remedial statute here, Your Honor.
Well, but it didn't, to follow up on Judge Stein's question, your argument seems to be that my client's the aggrieved party here, and they've suffered a pecuniary, there's been a pecuniary effect on them. And it seemed to be that the appellate division, and you can comment on this, almost acknowledged that. They seem to say that, yes, that they are the aggrieved party, but that this is really for the court to obtain jurisdiction. It's a condition precedent to the filing of the assessment, or the grievance, I guess it's called here, that it's got to be done by the person or party that owns the property, and in this instance, it was the trust. And so they're constrained. They don't even have jurisdiction to address the question of an aggrieved party if the wrong person has filed. So while you may be 100% on the aggrieved party argument, it seems a difficult problem that they saw, and that is being argued to us, is that that the court really could never obtain jurisdiction because the wrong person's name was on it.
Your Honor, they did find, the appellate division did find that we were an aggrieved party under Article 7. Where they erred is finding that...
Yeah, right, 70 what? 704.
704.
Right.
Where they erred was determining that the condition precedent requires that the filing be by the owner. The only condition precedent is the filing within the time frame.
Right, so there's
Doesn't have to be by the
We both
owner.
understand it in the same way. That's what the appellate division said to us, right?
That's correct.
Yeah, and so why doesn't the court have to obtain jurisdiction first before it can look at the issue of the aggrieved party?
They do.
Isn't that what you need to address for us?
Yes, the obtaining of jurisdiction here in a real property tax matter as interpreted under Miller, as interpreted under Sterling Estates, is simply that during the time frame, during the specified time frame, that a grievance be submitted in writing that sets forth identifies the property and sets forth the grounds. The name on that grievance is not jurisdictional in any way. It's at best technical, waivable, and curable. This was never raised by the town.
I don't always do this, but let me just give you an example. It seems particularly harsh here because we're talking for a trust, and one of the beneficiaries is the person who's actually, of the trust, is paying it here. But what if the name on it was something other? What if it was a Buffalo Pancake House, and someone had written the wrong phrase in with the wrong identification in? Would that be someone in the office filing the papers, say? Would then the court have jurisdiction, even though someone else had?
If it said Kevin Klein, Your Honor,
Right.
it's still not a question of subject matter jurisdiction.
I
It
see.
can still be, it's a technical issue. The name on the grievance, as the courts have held, especially this court in Miller, in that particular case, Miller, some of the grievances were filed for a former owner, and they were not found to be questions of subject matter jurisdiction. They were found to be technical errors that can be cured when raised. The town never even raised this issue to allow us, if there were a defect, to cure that defect. I submit there was no defect, but the name is not a jurisdictional issue.
Thank you, counsel.
Thank you, Your Honor.
Counsel?
Good afternoon. William Maker Jr. for the town of Mamaroneck. I was going to start my presentation at a different point, but I want to pick up on what Judge Stein was saying because I think she's 100% right. The grievance procedure is supposed to be simple. It's designed to be a simple process. It's designed for owners to be able to do it on their own. But for that owner who feels the need to have assistance, that owner can appoint a representative. But it starts with the owner, and that representative could be a tenant. It could be somebody who might acquire title to a piece of property by virtue of a trust. It could be,
Well, so is your argument that the beneficiary of the trust, right, Mr. Gast, who signed an authorization authorizing the law firm to be that person, is invalid?
her authorization was on behalf of the Larchmont Pancake House, which is not a beneficiary of the trust. That's where the conflation that I believe Judge Stein was talking about before comes back. The Larchmont Pancake House has no interest in this trust. As a matter of fact, Mr. Gass had an interest in the trust, but as we all know, certain trusts have expenses and debts, and they never execute that which they're supposed to do.
So just to be clear, you're not saying that the authorization was invalid. That is, Ms. DeGast is an owner, at least a beneficiary through the trust. She can, would she have the power? What I'm getting at, is the problem that it says Larchmont Pancake House instead of saying the trust? Is that the problem?
Yes, the problem is that
And is that problem evident on the authorization or on the petition? Which is it that's the problem?
It would really be on both, because the owners of the trust were the two trustees, Kevin O'Donnell and Kimberly Corbin. Ms. DeGast, of course, is neither one of those. She wasn't one of the trustees. And what we're talking about here is the Pancake House, a corporation, bringing on this litigation through the grievance process.
Hey, but why isn't this a pleading technicality? You know, in a normal action, if someone sues me and they sue me as E. Fahey or Edward Fahey, and I'm actually Eugene Fahey, you can amend the pleading later, and it's a pleading technicality.
But we're not talking about somebody suing you with a misnomer.
Mm-hmm.
We're talking about a corporation suing when there is a potential beneficiary who's an individual. They're not the same person. And if the law says that you can
That's
have...
where we get into the subject matter jurisdiction question.
Correct, because in order there to be subject matter jurisdiction, a proper grievance has to be filed.
Mm-hmm.
And so as Judge Stein started us down the road, that it is supposed to be a simple thing. As a matter of fact, the representative can do all the work. They can research the property values. They can look to see whether the property is overassessed or illegally assessed. All that the 524.3 requires is for the owner to sign the complaint.
Do you know to whom the tax bills were sent?
I do not. They probably were still in the name of Mrs. Carfora, the decedent, because there was no deed changing title until 2013.
So you don't know the address it was sent to either?
I would not know that. It probably was sent to Mrs. Carfora's address.
But the payments, were all from Ms. DeGast. There's no doubt.
Oh, not from Mr. Gass, from the Larchmont Pancake House. And I think it's important. I mean, if
Now,
people,
who signed the check?
I don't know who
Didn't pay
signed the check,
cash,
but
right?
an
So-
officer of the corporation. It could have been Mr. Gass, it could have been somebody else who's an officer. I do not know those details. But the point here is,
But every one of the checks was cashed, correct? Yeah,
Oh, yes.
They've paid the taxes.
the taxes were paid.
Yeah.
Yes, there are no two ways about it. And as I think Judge Stein was also saying is, this isn't determining who's aggrieved. It's not the province of a Board of Assessment Review. They're there to talk about value.
Well, there's really two issues in this case. We may or may not get to both of them, but the first issue has to do with whether the grievance was properly filed in the first place. The second, or the other issue is, as for the Article 7 proceeding, was she an aggrieved party?
Well, it wouldn't be
And-
Ms. DeGasse, it would be the Larchmont Pancake House.
Or would either one of them be an aggrieved party? But
I argue no, because there is no tangible connection between the Larchmont Pancake House and this piece of property. Usually, these cases do come up with tenancies. So a tenant has a lease. The lease says, "Thou shalt pay the taxes," directly to the taxing authority, and therefore that triggers the process.
So you agree that if there was a lease, if there was a legal obligation between the actual title owner and whoever was actually paying the tax bills, that would be enough to demonstrate aggrievement?
Agreement? Oh, sure.
Okay, so-
I don't think there's any doubt about that.
Okay,
The-
so
the
triple
issue-
net lease or, whatever.
Yeah, whatever it is. But here, of course, there is no
Why
such
can't
agreement.
they establish an oral lease?
Well, so far, they don't claim to be a tenant. The record only calls them occupants. In two places in the record, the word occupant is used.
Well, no, doesn't the record also have a couple of affidavits that says that there was an arrangement for the Pancake House to pay the taxes and other expenses for the property?
Yes, but it's not contemporaneous when the events occurred. This was after this whole litigation
No,
began.
I think it alleges all the way, I think it alleges all the way back to 1995 when Mrs. Kafora was still alive.
Well, when Mrs. Kafora was alive, she owned the property in her own name, so she.
But it was the
she
Pancake
fine.
House that was paying the taxes according to those affidavits, not she.
They-
And to you, it's important, the legal difference between the corporation and these individuals and the trust, those differences are important to you.
That is exactly right. But let me get back if I might.
And
to-
DeGast was permitted to be on this property without paying rent. Right? There's a recognition that otherwise that would have been the relationship.
I don't know how to describe their relationship. It's nebulous at best. It's nebulous at best, and to get
She's not a
back.
trespasser.
Well, but that sort of begs the question then, if it's nebulous and this is on a motion to dismiss, why don't they get a chance to see what the facts are?
Because of the fact that the procedure was not properly filed in filing the grievance in the first place. So we get back to the other.
You're on the Article 3 now.
Back to Article 5.
I'm sorry, 5.
The second of what Judge Stein just alluded to before, and that is the phrase, "person whose property is aggrieved," 524(3). That is the rub here. And to me, and the other phrase, as we all know, "person claiming to be aggrieved by an assessment of real property." These are two very divergent phrases. There's no similarity in between any of them except for the use of the word "person" and the word "assessed." As you have said many times, including most recently, I think, in the Brancaccio case, when the legislature uses unlike terms in different places, it's important it's reasonable to say they have different meanings. So if you were to decide that these two phrases meant the same exact thing, you would render one of the phrases superfluous and unnecessary as something that you have said in many, many cases should be avoided. Under Article 3, the only asset that can be assessed in New York State is real estate. It's very clear about that. As a matter of fact, Section 300 specifically says personal property, intangible or tangible, cannot be subject to ad valorem taxation. So if the only property that can be assessed is real property, and the person whose property is assessed can only be the owner of the property. It is not a difficult or ambiguous statute whatsoever, and you view it in the context of Article 3. My time has expired. I wish you all a very pleasant afternoon and a very happy Valentine's Day tomorrow.
Thank you, counsel.
That wasn't fair.
Mr. Klein?
It's tough to top that, you know?
That was very good. Your Honor, the Article 5 and Article 7 have to be read in harmony. They have to be harmonized. The fact of the matter is Mr. Maker is arguing that person whose property is assessed means something, has to mean something different than aggrieved party. It's unfortunate that different language was used.
That's not the way I'm reading it. The way I understood his argument was that he's drawing a distinction between an administrative challenge and a judicial challenge. That's the way I understand the argument.
Well, there is not any. And the McLean's case that was ultimately cited by this court in Walbaum makes it very clear that anybody...
Go ahead. I thought the petitioner there had an obligation, a legal obligation to pay taxes. That's not the case here.
That's another issue. Whether or not a lease is required, a lease is only an indicia of a direct adverse impact. It's not required. In all of the cases that talk about specific lease language, a fractional tenant was involved. We paid all the taxes here. We occupied the property in whole, paid all the taxes for all the years under review. Article 5 has to mean, if the administrative process is to mean anything, as this court laid out very clearly in Sterling Estates, the entities who can file in Article 5 have to be the same as...
It would be odd, would it not, to write a piece of legislation that authorizes more people to bring the judicial proceeding than the administrative, when the administrative is the condition preceding.
Excuse me, Your Honor.
No, go ahead.
No, it does seem to dilute the efficacy of the administrative review process if more people can file in court that can file at the
Well,
administrative
it's
level.
illusory if it's a condition preceding, right?
If it's devised with the intent of reducing litigation. The only thing we know from a plain meaning language reading of the statute, that person whose property is assessed does not mean its owner. The legislature uses the term owner repeatedly in Section 554, in various places throughout the real property tax law. So Mr. Maker's argument plays against him here because it cannot mean owner. It's the only thing that it cannot mean is owner.
Thank you, counsel.
Thank you.